Today's topic is case law updates led by Dawn Barthel and Brittany Rothe-Kushel. Dawn is the founding partner of Bradford and Barthel, and we are about to celebrate our 25th year, if you can believe that. Dawn has been teaching workers' compensation professionals for years, and he's also known for his hilarious, although sometimes cheesy, jokes. Brittany is a seasoned attorney out of our Los Angeles location. She just joined our diversity team as a diversity officer, and I highly recommend that you read her recent blog post where she talks about Governor Newsom's new bill barring NDAs. There are a couple of B&B attorneys on who would like to say hello, and I think we're going to start it with Rosa.
Everyone, my name is Rosa Sanchez-Irvin. I'm at the Ontario location, and we provide our services at the WCB in Pomona, Riverside, and San Bernardino. I've been with B&B for over a little bit over 13 years now, and I am also the Director of Diversity and Inclusion, and I'm looking forward to working with and continuing to work with some of you.
Thank you, Rosa. Juliana.
Hi, everyone. My name is Juliana Crawford, and I've been practicing workers' comp for about 5 years. I work out of the B&B Ventura office. I normally try to cut off discovery early, but I also can be aggressive if it is necessary. I really enjoy travel, and I'm really excited about Thanksgiving because I will be spending it in St. Lucia. So, but I'd love to work with you guys before and after the Thanksgiving week.
Thank you. Brittany.
Good afternoon, everyone. My name is Brittany Rothe-Kushel. As Tammy said, I'm out of the Los Angeles office, and I'm newly appointed as a diversity officer along with Ms. Rosa. And I practice out of the firm's Los Angeles office and handle the LA, Marina, Van Nuys, occasionally Long Beach boards. I've been practicing for over a decade. And fun fact about me, I like to run marathons. So it's part of my stress relief as of 10 years ago. So when I'm not aggressively handling your files or spending time with my family, you can find me running.
Nice.
Forward to working with all of you all. So I know I have a lot of you all cases with me. So looking forward to continue to work with you all.
Thank you, Brittany. Hey, Don.
Hey, first off, I want to say hey to everybody and thank you so much for spending some time with us. Second, I want to say you might wonder why this mask is over my face, but those of you who know how ugly I am realize that it's a favor to y'all. You don't have to look at me. Well, so much for that. And two, it is our newest and best Bradford and Barthel mask, double thickness, adjustable. So if you'd like one of those, by all means get one. Let Tammy know you'd like one, and she'll get it right on out to you. What am I known for? Very little of any significance other than really bad jokes. And so why should today be unlike any other? So a gentleman, his wife and his mother-in-law go to the Holy Land for vacation, and unfortunately the mother-in-law dies. And they go to the undertaker, who explains to them that they can ship the body back to the States for $5,000, but they can actually bury her and prepare her in the Holy Land for $200. The guy says, we'll ship her home. The undertaker says, now, are you sure I explained this properly? For $200, you can have to take care of everything, but to send her back to California, it's going to cost $2,000. I mean, that's an awful big expense. And the guy says, listen, 2,000 years ago, they buried a guy here. 3 days later, he rose from the dead. I just can't take that kind of chance. Okay, I told you I was no good at jokes, but I keep trying. Let's talk about California workers' compensation. Oh, let's talk about COVID. Don't like the COVID, but we're getting sick and tired of that. But nevertheless, I don't think we're going to get rid of it anytime soon. The Brooks matter. This is an older case, but there's been a number of cases that have come subsequently to it, and they've been very much on point. So I thought it was important to return to this. There was a claim for an attempt by the applicant to get outside of workers' compensation. They said, well, you failed to protect me from COVID, and therefore this shouldn't come from this shouldn't be workers' comp. This should be an intentional infliction of emotional distress. Well, you can imagine the uproar that would have occurred if that had been successful, and thankfully it was not. It was dismissed. They said, nope, you got the exclusive remedy bar, and there was nothing here that fell outside the employee-employment relationship. So hallelujah, we're all good. Now, liens, this is a fun case, another fun case for the employer. Ross, deceased, there was a $2.1 million lien, a $2.1 million lien. Don't see a lot of those very often. And it was filed 18 months after the date of service. The record contained a lot of pleadings in which the employer referred to the lien, so it was clear that the employer was on notice of the thing. And the question was, is this barred by the statute of limitations? Well, if the employer is on notice of it, but it's of the lien, but the lien's not filed in a timely fashion, what happens? It's barred. So it just put $2.1 million away, lien claimant. Gotta love it. Reason? Well, there was no evidence, they said, that the employer was naughty. There is no evidence that the employer knew of this error. There's no evidence that the employer, in any way, shape, or form, waived the defense of statute of limitations. There's no evidence that the employer did anything funky to intentionally cause the lien claimant to believe that it actually filed the lien. And there was no evidence that the employer had somehow caused the lien claimant to forego timely filing the thing by somehow through its the employer's bad conduct or bad statements. So there were no unclean hands, is the magical phrase in the law, on behalf of the employer. So statute of limitations is a statute of limitations. Remember in the bad old days when statute of limitations are largely ignored? That's not true so much with the new legislation. All right, what about terminated employees and temporary disability for them? Once we terminate them, we certainly don't think we should be liable to pay for TD. And how does that work? The employer accommodated the employee's temporary work restrictions for about 30 days. Then all employees were sent home due to a COVID emergency orders. Okay, so if everybody is off work, why should the employer or should the employee with TD be the one to receive continuing payments? That doesn't seem quite fair. So in rephrase, is the employee entitled to continuing TD when the employer has been shut down and all the other employees have been sent home because of a COVID order? The problem with that answer is it's in the affirmative. Yes, unless the employer can prove that the employee was terminated for, quote, good cause, end quote, we're going to be stuck with it. What is the theory here? The theory is that if, but for the injury, somewhere the employee may be able to find a job. Maybe it was not in California. Maybe it's not in their city, but somewhere they may be able to get a job. But that injury precludes it. Additional termination was not for cause. So there we go. Salazar versus Kodiak. The employee was offered modified work. He was offered modified work, but could not take on the job because they were undocumented. Well, does this seem fair? That they're not, are they entitled to TD? Does that seem fair? Yeah, it does. If you really take a look at it, the employer would be treated disequally under the law. In other words, the equal protection clause, the constitutional provision of the equal protection clause would be violated if the employer were required to provide more protections and more benefits to employees who are illegal than to legal employees. And that is nothing new. About 25 years ago, that same rationale was utilized in the Del Taco case. You might remember that. Hopefully, maybe you don't remember that. It's been too old. I do remember it. But that was dealing with workers' compensation. And the question was whether the employer, vocational I can't talk today. Oh my goodness. VR, vocational rehabilitation. The argument was that an employer could avoid VR responsibilities if they offered had a good faith offer of modified work, and the employer said, yeah, but I can't have a good faith offer of modified work if this injured person is illegal. And it was held once again that the Equal Protection Clause applied, and that in that situation, the employer did not have to make the offer, and did not get stuck with VR. All right, Rome versus Department of Social Services. Who is that? That is Freud. For those of you who may have studied psychology in college, what you call what's a Freudian slip? It's when you say one thing but mean your mother. But I'm fun. The telltale doesn't look good at these jokes. So applicant's counsel wanted to attend the psychiatric medical examination with the employee, which is going above and beyond, I think. And not a lot of applicants' attorneys want to go to these things because, hey, it's out of their pocket. They don't get paid for that exercise. Nevertheless, was that allowed? And the answer was absolutely not. Not a psych exam. The attorney can attend any physical exam, but not a psych exam. In fact, neither the applicant's attorney nor a court reporter may be present. Interestingly, though, they can record it via an audio tape. Wow, now that's an old school audio tape. If they think something's suspicious with regards to how the examination is going, then they are invited to record it. Padilla. This is an interesting little case. The employer representative, in fact, the employee's direct manager, it was held by the panel, could appear at a psych deposition. In this situation, the employee's brakes on his bus failed. He hit a pole, and he filed a workers' compensation claim. It's important to note he filed a workers' compensation claim. What does that mean? It means there's going to be discovery. The employer's assistant transportation manager attended the deposition, and the applicant's attorney told his client, don't answer any questions regarding medical history or psych history or your medical conditions, not while your manager is here, because that's a violation of your right to privacy. Well, is it a violation of their right to privacy? Oh, heck not. Although the judge granted a protective order, the WCIB said, no way, not at all. You've waived your right to privacy by filing the workers' compensation claim. At least you've waived your right to privacy with regards to relevant questions. In this case, psych, pretty much anything is relevant. I would never file a psych claim, because what's relevant to psyche? Freud, we're just taking a look at Mr. Freud, said that our potty training was relevant to our psyche. So just about anything under the sun would be related to, or rationally related or calculated to obtain discovery with regards to our psyche. The deposition questions are always fascinating in psych cases, at least when I take them, because I love taking these suckers. The most interesting question I ever had the joy of asking, mean question, was, ma'am, now this is a psych case, not going to get to ask this one in a low back case, but in this psych case, it was, ma'am, did you give your husband the STD, or did he give you the sexually transmitted disease? Now, there was an objection, but it wasn't firm. I know very well that applicant's counsel didn't think that they were going to win on that, and the case settled very, very quickly. Sadly, I didn't get an answer, not surprisingly though. Alvarado, this is a very interesting case. The judge referred to a lien claimant as, quote, the bottom of the barrel. And the judge actually discredited the lien claimant's billing without actually reviewing the evidence. The attorney claimed that he met with the judge in chambers and actually asked him to recuse himself. That is the attorney for the lien claimant. And the judge said, I don't even remember that kind of conversation. That didn't really happen. The question here is the judge disqualified? And I think hopefully this is fairly obvious. The answer is heck yes. Now, what if we know, we can look into the judge's heart and know that he or she was totally innocent and had pure thoughts and would never make a decision based upon these comments about being the bottom of the barrel. It doesn't matter. The test is whether a reasonable person could entertain thoughts concerning impartiality. When a judge refers to somebody as the bottom of the barrel, you're pretty sure that a reasonable person could entertain such thoughts. So based solely on the appearance, not on actual bias, which would be very difficult to prove, but on the basis of an appearance of bias, the lien claimant's petition disqualify was granted by the WCAB. I'm going to skip this one because it's not one that's going to impact a lot of people, and we want to get through absolutely everything. All right, after permanent stationary, this is a crazy case. This may make your blood boil. After being made permanent stationary, or MMI, the employer termed the employee for sexual harassment, but they made no offer of mod O. Of course you don't want to make an offer of mod O. You just fired the person for being very naughty. So are they entitled to an SJDB? I told this to make your blood boil. Yes, the answer was yes, because they didn't make a bona fide offer of regular mod or alternative work, and regardless of whether the employee is entitled to make such a offer, regardless of the employee's ability to accept it, the employee is entitled to an SJDB. Now you might say, okay, then we should just always make such an offer, regardless of our ability to make one. But can you make a good faith, or rather bona fide offer if you know that you won't hire them? That's an interesting question, and it's not exactly the way it was phrased in this case. So something that we still need to consider. In other words, perhaps we should always make an offer, even when it's impossible for us to gain an employment if they ask for it. All right, one other crazy one, Urias, the applicant voluntarily resigned. Well, the employer said, they don't get a voucher because that's not an option. They've quit. Why would we offer a voucher if that's not an option? How can returning back to work even be an issue since the relationship with the employer has gone belly up? Are they entitled to a voucher even though they voluntarily resigned? And the answer is, nevertheless, they are. The WCIB said, we conclude the applicant's resignation has no bearing on his entitlement to a voucher. That's the last really stupid case I'm going to give you today. All right, unreasonable delay. Here's one that we all need to do or know, because every once in a while, we're all going to face this situation where the employee or injured worker or applicant claims that they not received their payment. In this particular case, the employee announced that he'd not received a check for $51,000. Replacement was reissued 22 days later. The question is, strike that. And a week thereafter, it was actually received, or it was stipulated that it was received. And the question is that response reasonable? And if not reasonable, what does that do to the employer? That is not reasonable. 29 days is not sufficient. They said that although we have a duty to investigate whenever it's claimed that a check is not paid or received, but we have to act diligently. Apparently 29 days is not diligent. The delay must be corrected, quote unquote, promptly. How long can it be allowed? In other words, how much time do we have? It's not clear. There's not a cut and black and white answer here. But if we have a satisfactory explanation as to why there's been a delay, apparently it can be more than 29 days, it can be less than 29 days, it can be 29 days. So I certainly would try to make it less than 29 days, but definitely make sure you've got an explanation as to any reason for any delay more than a few days. What happens then to the employer? 10% penalty and attorney's fees of $3,200, which is pretty significant given the fact that the check was only $50,000. Serious and willful. All right, I always, when I'm explaining serious and willful to people who are not involved in workers' compensation, I say, this is a situation when the employer was super stupid, and any reasonable person could have seen that an injury somehow along the lines was possible, if not probable. In this case, the prison guards were attacked by gang members. The associate warden and captain had failed to act on a memo. There had been a memo warning of that the inmates were planning to attack the staff. They didn't circulate that sucker, and some witnesses from the employer said memos should always be triggered, trigger an investigation and result in a lockdown and cell searches. That was not done. S&W, I think the answer here is pretty obvious. Yeah, this was incredibly stupid. And sure enough, that's exactly what they had said, that this was incredibly stupid. Failure to send a memo to supervisors was, quote, more than a, quote, mere passive failure to act. It was an indicative of, quote, an intentional disregard by the employer, specific and identified risk to employee safety. Like I said, really, really stupid. Interpreters, this is the one that drives me absolutely crazy because it makes no sense legally and it makes no sense logically. Right now, an interpreter was provided. Who's permitted as entitled to an interpreter and the benefits dealing with Labor Code Section 5710? Employees. Turns out this person was not an employee. They were an independent contractor. So should the business that was allegedly the employer be hit with the bill for an interpreter? Oh, heck no. They were only on 5710 applies only if you're dealing with an employee. So we shouldn't have to pay for this bill, right? Right? Well, turns out that the WCIB disagrees with my logical rationale. They say that 5811 interpreter fees must be reasonably, actually necessarily incurred and must be paid by the employer. Huh? I just said that. There need to be interpreter paid by the employer. We don't have an employer here. Employer, they said, is any defendant against whom a claim for benefits is asserted based on the alleged employment relationship. Now, here's their rationale. They say otherwise, if we allowed interpreters not to be paid when on the very occasional basis, the claimant is determined not to be an employee, we're going to have difficulties getting the help from interpreters. Do you really believe that? I don't buy that for a second. So I have every expectation that the WCAB will hold this way every time, but darn it, they are wrong. Law enforcement do-gooders. This is a very specific case that will apply to very few of you, but I want you to make you aware of a bigger situation. In this case, a couple people were injured after responding to a officer's request for help. That they respond to a 911 call for unspecified help. In other words, the officer said, "We've got a 911, I need help." Didn't explain why they need help, but two citizens said, "Okay, we'll help." They were injured. They filed a civil claim saying, "You failed to tell us what the dangers were." And the answer was, "No, this is a workers' compensation case. Got exclusive jurisdiction." Now, is this a workers' compensation case? It doesn't seem like one, but as a matter of fact, it is one because there's a labor code section, 3666, that that expressly provides this in this situation that persons assisting officers in the active law enforcement service at the request of the officer and during in these particular situations are employees. Why do I tell you this particular case? There are lots of other areas where you wouldn't think of the individual. You might think of the individual as an employee, but they're not. And other situations where they are deemed an employee, but you wouldn't necessarily think they were. The down and outers, for example, who go through a work rehab through the Salvation Army or the Goodwill are not considered employees, even though that it's a work program. They get paid a small stipend, etc. The legislature has just determined that they don't want to have organizations like such as the Salvation Army subjected to workers' compensation claims. They want to defend the Salvation Army from such costs. Similarly, this applies to ski lift runners. Okay, the Lou case. This is an issue of going and coming rule. The applicant was in a parking lot across from the street from her job and was robbed. And the question is, this is compensable? Well, the going and coming rule says it's not, because once you leave your work, you're on your own, and once you get back to work, you're on the employer's dime and therefore covered by your employment and thus subject to the workers' compensation rules. However, the question is, and again, this is part of the regular commute, is there an exception to that? The special risk exception to this? And there is none, because there was no evidence that getting into this parking lot or going in this parking lot was more dangerous to employees of the Oakland Unified School District than to other people, so who are not employees of the Unified School District. So for once, the going and coming rule actually works as a successful defense. It's often very often a difficult defense to succeed with, lots of exceptions to the going and coming rule. So we want to make note of the situations where we actually win. Frere, interesting case of great importance. Labor Code Section 4662, the statutory 100%ers. According to Labor Code Section 4662, if we blind you, your upper extremities don't work, your lower extremities don't work. And one other thing that I'll go over very quickly, you're statutorily 100%. You don't have to go to the AMA guides, you don't go to the GAF score, you're just 100%. In this case, the individual is deemed 100% because of loss of both eyes. By the AME. They said he is legally blind and therefore 100%. However, he split it up. He said 60% of this is work related and 40% was not work related. And but nevertheless, the judge said there's no apportionment because they are conclusively presumed under 4662 to be permanent for their disability to be quote unquote total in character. Well, what do you think? Should that mean that there is no apportionment if their 100% total is conclusively presumed? The court said no. Let's go back a little bit. Any of the following permanent disability shall be conclusively presumed to be total: loss of eyes, loss of hands, practical total paralysis, in other words, in a wheelchair, and injury to the brain resulting in permanent mental incapacity. All right, so what about this loss of eyes or thereof? And in all other cases, permanent disability shall be determined in accordance with the fact. They said, no, you still get apportionment under 4663 and 4664. There's Benson under 4664. Anybody remember Benson? meaning you're very old like me. Why do you still get Benson despite the fact that it's conclusively presumed to be 100%? Well, it's conclusively presumed, the injury is conclusively presumed to be 100%, but that doesn't mean it's conclusively presumed that there is no apportionment. And it has to be remanded down to the judge for the judge to apply Labor Code Section 4663 and Labor Code Section 4664. In the WCAB's own words, the clear and unambiguous language of the statutory apportionment that requires that apportionment be that apportionment of PD, whether it's permanent in total or permanent partial, shall be based on causation. In other words, shall be subject to apportionment. They said, listen, one of the dissent said, no, that's just not fair. And they said, well, it may not seem fair, but what about the poor employers? Employers are not going to want to hire people who are disabled if, for example, they already are missing one eye. If the employer causes them to lose a second eye, now the employer, under the dissent's perspective, would be stuck with 100%. That just doesn't make a lot of sense. Why would you set up a situation where the employers, prospective employers, are less likely to hire the disabled? All right, I'm gonna skip this one real quick because I'm going to pass off to Brittany in short order because I'm already past my time. This isn't very important. Don't get in the weeds of these facts. I want you to get a general understanding of the facts, but that's not really the point. Raison versus Southern California Permanente. There was a mental injury from the assault. The doctor said you can return to work if you go to some other facility where the attack didn't occur. The employer only had work available where the attack occurred, so the employee had no business or had no work available to them. The employee said, this is a FEHA, this is a Fair Employment and Housing Act violation, sort of like the ADA. I was injured, have disability, and you discriminated against me on ability, based on that disability. Now, the case in chief was settled by way of CNR, and there was special language in the CNR. It included a voluntary resignation with a waiver of monetary damages for any causes of action arising directly or indirectly out of the employment. In other words, it was the garbage can language. Everything, you've just settled anything and everything. Very much similar to the language you used to use back in the old days, and we used to get away with. The question was, is the FEHA claim waived? And some cases will say no. This one actually said yes, and it gives a pretty good explanation. And this is the Second District Court of Appeal. He said the resignation was voluntary, and it was a condition of the CNR. It was consideration, that is, some benefit was derived by entering into this agreement. Even if consideration were required, the CNR was a benefit that constituted consideration to the applicant. It's irrelevant that the employer didn't sign it. Remember that an employer, an attorney representing the carrier actually signed it. Doesn't matter that the employer didn't sign it. The release of non-workers' compensation claims can be effected via a separate document. Just because you're not using the workers' comp pre-printed form, you can use a separate document. And the CNR need not make express reference to the FEHA claim that is to successfully bar it. So take that. We can do the employer a big benefit, provide the employer a big benefit, although don't go down this path. Don't tell the employer, we are going to get rid of the FEHA Act for you all by our lonesome. Definitely want to get the FEHA lawyer, get the employer to hire a FEHA lawyer before, otherwise we could possibly get involved in a malpractice claim. Okay, we're going to skip Munoz. By the way, all of these are in your handout, so you will be available. They will be available to you. Okay, well, I've skipped Munoz, which means It's time for Brittany. Since I've already gone over 9 minutes, I think it's definitely time to go to somebody who really knows what they're doing. Sorry about the bad jokes, and have yourself a wonderful day, y'all.
Thank you, Don. This next case we're discussing is the applied materials case. It's a case that came out in June of this year, this summer. It involves an applicant who alleged multiple injuries over the course of her many years working there. One of them included a PTSD psych claim that stemmed not necessarily from work, but from a treating psychologist who sexually assaulted her. So in this case, there was a psych QME, thankfully didn't act crazy like the psych PTP. He assigned PTSD and a GAF score of 45. And there was a determination that this was 100% PD solely based on the PTSD from that bad doctor. And the trial judge awarded a 100% award based on that and relied on Labor Code section 4066-2, which stated any of the following permanent disabilities shall be conclusively presumed to be total in character. And that includes loss of both eyes or the sight thereof, loss of both hands or the use thereof, and injury to the brain resulting in permanent mental incapacity. And section B, in all other cases, permanent total disability shall be determined in accordance with the fact. And I think the trial judge ran with subsection B in making that 100% award. So the issue is, does Labor Code section 4662B alone support 100% PTD award? On appeal, the answer was no. And this is why it's important for us to have vocational rehab experts to determine whether or not there's diminished future earning capacity or ability to return to work in some capacity to overturn that 100% PD award. Here, the reasoning was Labor Code section 4662B allows the work comp trial judge to make a PTD determination in accordance with the fact. Labor Code section 4660 addresses how that determination of the facts shall be made for dates of injuries prior to 2013. That would include looking within the four corners of the AME guidelines, look at diminished future earning capacities, occupation, and age. In this particular case, the applicant relied on the alternative theory. These options are discussed from prior cases that we're all aware of, the LaBouffe case from 1983. In this particular case, the applied materials case, the QME did not opine regarding ability to participate in voc rehab or take advantage of training opportunities or to find work. The QME was not a voc rehab expert. Thus, he's not qualified to be a voc rehab expert to discuss options and whether or not an applicant is 100% disabled from working in the open labor market. What are some of these alternative theory options? We look at the 2010 case of Milpitas Unified School District. In this case, the QME did not explain why whole person impairment did not accurately reflect disability, nor did the QME in the alternative theories case provide an alternative rating, which omitted the GAF scale and explained why the rating more accurately reflected permanent disability. So, in this case, the appellate board wanted to avoid WCAB using 4662B to rely on ad hoc decisions making. So, as a reminder, we can only rebut AMA PDRS by proving that the applicant is not amenable to rehab or challenging the standard rating within the four corners of the AMA guidelines. And also it's imperative to have a voc rehab expert when we do have those cases where we're challenging 100% permanent disability. And as a reminder, as much as qualified as doctors are, they are not qualified to opine regarding ability to participate in voc rehab. That is, of course, left to the voc rehab experts. So we can expect lots of VR expert bills. We recommend a lot. You can speak to us after this presentation. If you have 100% cases that you need us to assist you on, which voc rehab experts we would recommend, we'd be happy to discuss that with you. Okay, so the next case, Khan versus Denny's Restaurant, is also a 2021 case that discusses med legal expenses and payments. And in this case, the QME billed $11,250 along with P&I for a psych med legal exam. and the parties stipulated that the defendant's EOR was untimely. The QME's report was super long, 113 pages, and included about 45 pages of record review on times. So the QME's report, the trial judge had held that the QME's report and invoice were substantial evidence that the billed amount was reasonable. The court held that this shifted the burden then to the defendant to prove that the billing was unreasonable. And unfortunately, defendants in this case failed to satisfy that burden to prove because it was all speculation. They didn't provide evidence. So to dispute a QME bill, you need to come with more than speculative evidence. This can include bills from other comparable QMEs or the same QME or physicians, et cetera, to challenge QME billing, bill reviews, that would help. And also, as you all are aware, there's new CCR 9795 regulations that limit how many pages we can give to the QME beyond being charged like $3 per page. So in this case, we always work with the opposition to reduce the necessary medical records to provide to the QME to mitigate the cost for the QME, but also make sure we send the most relevant ones. So the next case addresses MPN treatment, and that includes a 2021 case called Richmond versus Polymetric Technology. And in this case, there was an applicant in 2020 who requested a change of a PTP, but the defendants failed to respond right away. The applicant, through her attorney, argued that there was a denial of care based on that defendant's failure to provide a change of a PTP until February 2021. In February 2021, it's like 6 months later, defendants provided an NPN link and authorized and transferred the injured worker to a new NPN treater 3 weeks later. The court held that the defendant's delay in responding to the applicant attorney's request for a PTP change did not constitute a refusal of treatment, and held that the injured worker failed to provide evidence of treatment or efforts to obtain treatment after the September 2020 request. And also, it's important to note that the 20-day time limit for medical access assistant to schedule an appointment pursuant to the code only applies when scheduling appointments with a referral-based specialist. So for example, if you have a hand injury and there's a recommendation for a hand specialist from Cedars-Sinai, then yes, that needs to be set up with the medical access assistant within 20 days. The next case, Carla Gonzalez, it's a 2021 case. This case, the applicant injured her right ankle in 2013 and 2017 while she was employed as a janitor for AC Transit. She wanted to have ankle surgery with a physician at MCI. This clinic happened to be outside of the network. The physician requested the surgery in September of 2020, and defendants objected to this treatment as being outside of network. Ultimately, though, it was determined that this applicant could seek this surgery outside of the network because at the time of the original request, this facility was within the MPN. And the triggering factor was not necessarily that the doctors were no longer in the network, it was the defendant's delay in approving the treatment. So continuity of care, especially when surgery is involved, you want to be careful to delay or deny treatment or continuity of care and treatment just because there's an MPN dispute. So you really want to look at the facts there. In the interest of time, I'm going to skip this case about QME telehealth procedures. There had been some litigation. Sometimes people refuse to have in-person versus QME, but overall, most people are agreeable and amenable to virtual QME proceedings. The next case, and I'm also going to skip the synergistic effect case because that one's a bit long. We don't have much more time. The next one is Spence versus City of Los Angeles Police Department. And in this case, there was a police officer who injured his foot in a basketball tournament with others from the Los Angeles Police Department. And the interesting thing is on trial, the applicant police officer testified that this tournament is voluntary. He wasn't encouraged or pressured to play. There were no promotions or benefits for joining. But he essentially testified that this participation was completely voluntary. So the question is, well, the supervisor also testified that the basketball tournament was listed in the LAPD manual, but didn't necessarily qualify as this is on-duty work. So the question is this AOE, COE? The trial judge thought it was, but on appeal, they said no way. So, and of course, it's pretty logical why. It's voluntary. If it's a voluntary participatory action, it's not necessarily AOE, COE. Labor Code 3600 A9. There's no AOE, COE if it's a voluntary participation in any off-duty recreational, social, or athletic activity. The exception is if these activities are reasonably expected or expressly required or impliedly required by the job, then it could be considered AOE, COE. Like I've seen cases for firefighters, like part of your job is to be physically fit. So if you are injured while working out on the premises, which could be argued as a requirement on the job, then there could possibly be an argument. Of course, we'd have to, as defense attorneys, find facts and evidence to support that the activity was completely voluntary, but there could be a silver line there. But in this case, for Spence, the activities were completely voluntary, so there was no AOE, COE. There's a two-pronged test under Labor Code 3600 A9. The first one is whether the employee subjectively believes that the participation is expected by the employer, and two, whether that belief is objectively reasonable. And in this particular case in Spence, the employee proved the first prong was met because he subjectively believed that this basketball tournament was voluntary, so no AOE, COE. So additional takeaway for us employers and defense attorneys, it would be helpful if we want to avoid a situation where we would have to litigate whether or not a tournament or anything like team building activities. We want to make sure that we avoid any that seeing as AOE, COE. The employers can expressly limit the scope of potential liability by designating and pre-approving athletic activities and fitness regimens. All right. This next case involves an improper applicant, Harrison versus Canyon Springs, a 2021 case. The OACR settled the CT ortho CR. The compromise when released was based in part on the party's mistaken belief that a $0 MSA did not require CMS approval. Come to find out, it did. The AME found no compensable injury, which formed the premise of the CNR agreement. And as a result of CNR, CMS began charging the improper applicant for medical treatment. But the defendant said, you agreed to the CNR, so you're stuck with the treatment. Of course, this case was challenged. Is there a good cause to set aside the order approving? The appellate judge said yes, due to the doctrine of mutual mistake. The parties mistakenly believed that the $0 MSA did not need CMS approval. And so I also like to think that because this applicant was improper, the board wants to go above and beyond to work in the best interest of this improper applicant. But that is something to consider, what grounds there are to set aside an order approving. All right, and this last case we have here is the Garcia versus Poker Flat Property Owners Association. And this particular case happened very recently, within the last 30 days, October 20th, 2021, a recent decision in the 3rd Appellate District. And it specifically addresses exclusive remedies, which serve as a bar for wrongful termination cases. In this particular case, the applicant or plaintiff was a former office manager for Poker Flats, which was a boat launch on docks, and it charged association members to use these facilities. In this case, the former office manager, sued her employer for wrongful termination, and she alleged she was terminated in retaliation for reporting sexual harassment and other violations to her Poker Flat board members. Some other facts to take note of, this former plaintiff made some serious egregious errors as an office manager, and she admitted that at trial. She was also placed on administrative leave for instances of financial discrepancies and accounting errors. That fact is very useful when it comes to the good cause for termination defenses that this defendant used. There was also a situation where when the office manager was placed on administrative leave, The office manager's assistant took over for a bit. She became overwhelmed doing her job and the job of her boss. And she took to the good old social media world and made it known pretty explicitly with some expletives how frustrated she was with the mounting work. Well, expectantly, this assistant was terminated. So the plaintiff sued for wrongful termination by poker flats and defamation. Defamation because her assistant put on Facebook how horrible of an office manager this woman was, and intentional infliction of emotional distress. So the question is, are these claims viable? And the trial court granted summary judgment in defendant's favor and concluded that the employer's basis for the plaintiff's termination was for a legitimate non-retaliatory basis. And those bases were the several egregious financial errors that the plaintiff did not dispute on the stand. She said, yeah, you know, I did make these errors. So essentially, this employer had grounds to terminate her. Now, on the appellate court level, the claim was barred by workers' compensation's exclusivity rule, and it fails as a matter of law. The appellate court affirmed the trial court's dismissal of this claim. So, what about the intentional infliction of emotional distress claims? That also failed. I mean, the plaintiff could not prove that the employer directed this disgruntled assistant to post these expletives on Facebook. And also they took action in good faith against her for making those expletives. They terminated her. So the plaintiff failed to prove that the defendant directed the claimant to, or the administrative assistant to go ahead and put those expletives out. So there you go. The workers' compensation exclusivity rules, and that's something you really got to be aware of in that case, the exclusivity remedy that bars wrongful termination cases in this situation. So with that, we have about 4 minutes before our presentation is over, and I wanted to give Tammy some time to make some comments here.
Thank you, Brittany. Thank you so much.
Thank you.
Thank you so much for joining us today. Thank you again, Brittany. You guys have a great rest of your week. Take care.